Welcome to the Best Florida Family Law Podcast. My name is Attorney Jonathan Jacobs. I'm so happy to be with you to talk about yet another interesting and ever-abundant topic in Florida family law. That is the date of termination of child support. Most law firms in family law receive a high volume of phone calls or email inquiries asking, when does my child support terminate? When does it end? Florida statutory law, specifically 6130, makes it clear, and yet it does not, because there are always exceptions and special circumstances in Florida family law and in most areas of law. The exceptions are what makes law interesting and what makes attorneys almost necessary under certain circumstances. For example, generally speaking, the statute provides that child support will end upon a minor child turning 18, or upon becoming emancipated, joining the military, and there are other circumstances as well. Those are the primary ones. However, special exceptions apply. For example, if your child is over 18, not yet 19, and has a, quote, reasonable expectation of graduating from high school before they turn the age of 19, then child support may continue for several months. Also, if your minor child or children have specific special needs and are not capable of sustaining their own income, or maybe not living on their own because of some sort of medical condition or otherwise, then upon the filing of a lawsuit, child support might continue indefinitely. Generally speaking, before 2009 and 2010, child support orders did not really have a termination date. Nowadays, we generally include a termination date and also include what we call step-down child support calculations. Step-down child support calculations are intended to tell the court and to tell both parties when the first child ages out, how much will child support be reduced to? When the second child ages out, and so on and so forth, how low will child support go? Of course, one of the biggest issues that most couples and former spouses face is that child support technically should change all of the time, even though it does not. You must either agree on a new number or file another lawsuit, a supplemental petition for a modification of child support. This is a difficult and very expensive proposition, which is why it does not happen more often, unless somebody believes their support will be lowered so much that it is worth the lawsuit because of the cash shortfall and financial disadvantages of continuing with paying a substantially higher amount when somebody's employment has changed, or they've been laid off from work, or their industry has changed, which, let's face it, with artificial intelligence and an ever-changing job landscape, is that really surprising that one day a person might make $125,000 a year, and 2 weeks later they are fired and cannot find replacement employment? That is an unfortunate reality of our increasingly global economy. Back to the child support issue. If your minor child is, let's say, 18 today, let's say today's January 1st, 2025, and your minor child will not graduate until May 31st, 2025, then technically child support should continue all the way up until June 1st of 2025. Also, if your minor child has joined the military and, let's say, dropped out of high school at age 17, and now they are abroad, I guess 18 is actually the age of enrollment, but they've turned 18, they're not done with high school, they've dropped out, and now they have been stationed abroad, deployed somewhere else in the world, should your child support terminate? Most likely. Now, is it a pleasant proposition for the parent paying child support to ask the Department of Revenue or the family court for child support to stop? No, it's not really a fun thing to do. Of course not. We're talking about your child and somebody that means everything to you. And the stopping of child support, of course, means it's no longer having that sort of financial commitment, no longer having that financial security for your child. But generally, we look to the statute. And whenever possible, when you are settling a case in mediation or privately, or if your case has to go to a trial, or If you have the unfortunate circumstance where your case is with the Department of Revenue, think very carefully about creating an end date for child support and or incorporating statutory law. This has been another episode of the Best Florida Family Law Podcast. My name is Attorney Jonathan Jacobs. Thank you so much for joining us again here today. Nothing that I have said constitutes legal advice. This is simply referential, informational, and entertainment. Thank you so much.